The next question is then, if we use the idea that the AI system is simply a tool, like other sophisticated tools which can solve certain tasks, if by an intelligent person, maybe he is the inventor or she is the inventor, set to solve that task, how is this product coming out there protected? Is it also patentable? And who is then the authorized person coming from the inventor who can deal with all that? There is a next question. Another question is, if you have an AI system which is patented, which could make new turbine blades, are you entitled to use that patented AI system to find out whether it can make certain turbine blades? Do we need a broad, in other words, maybe we need this, a broad exemption privilege for trying whether a certain invention is useful for a certain purpose? We have this in Europe largely. We don't have this in countries in that sense, like in the United States, where you have only the possibility, for example, to do certain experiments for pharmaceutical purposes, very, very restricted. We are much, much broader in Europe. And the last question is then also, do we possibly have to go back to reach-through claims? Would a product made by an AI system, put by an intelligent inventor onto a certain task and creating something new and inventive, would that product be, if you formulate the claim correctly, be protected as such, like we have discussed this question with research tools in pharma 20, 30 years ago? We denied that at that time. We said you cannot have a claim which says product made by a certain research tool assistance, and then you come out of 10 million substances which could have a medicament effect, a pharmaceutical effect, you could come to a new and inventive use. We said no research, no reach-through claims, please. No, you cannot protect this. These are all questions here in this context we wish to deal with, and Pravin has just, we had a little bit of time before you came in here. Before that, we talked already, of course. He said and volunteered, he talks about who should be the inventor in case of an invention made, and I'm very cautious now, with the assistance of an AI system. Maybe by the AI system or using it as a tool.
So here you have, imagine, and for ease of remembrance, remember the three letters, D for data, and A for the learning algorithm, and M for the model, DAM. Data, learning algorithm, model. So the data is used by a person to train the algorithm to produce a model. This is the learning phase. Now, in the learning phase, there is a human who defines the problem, converts the problem into mathematical terms, who then identifies the data sets, collects them, then he trains the algorithm, and then after the training phase, he verifies, provides annotations, etc. So there's a lot of effort done by that human in order to build a model. Today we have not reached the stage of artificial general intelligence where on its own AI will start inventing. That phase will come. But most authors, writers say that let's wait for that phase and then see what will happen then. Right now, let's talk about what is the present state of AI. In the present state of AI, you cannot divorce the inventor, the human, from the machine. Now, using the model, a third party produces a product. That's called an AI-generated product. The second question is, in this phase of applying that model, who is the inventor. In the first, it could be you have the obvious answer of either the human being the inventor or the human and AI being co-inventors. The machine alone is not the inventor. In the second, when a person is using the model to answer a query, in that the question is, the machine may be doing most of the job. And the question is the human entitled to be called an inventor or a co-inventor? In that, it would appear that a new breed of people are coming up, known as prompt engineers. Because depending upon what prompt you give to the model, you will get the answer. You may have seen from the New York Times case, right now it's not decided, but it's only a plaint in our language, which tells you that millions of pages of New York Times were copied and from various articles. And if you gave the correct prompt to Chat GPT, you could get a verbatim of the article that appeared in New York Times. So much so that the plaint illustrates original and the one generated using Chat GPT. In a case like this, obviously there is infringement of some sort. So I'm only giving a copyright example here just to illustrate the point. But of course, if it is like if I read a book, there's no copyright infringement for that. I don't infringe. So if the model is only looking at the data and not really reproducing, but learning, understanding from that data, then there may be no copying. So therefore, the classic tests of fair use would apply, the ones which were reproduced from time and from Campbell versus Akafros, the US Supreme Court case, a pretty lady, what is it, Pretty Red Lady or something like that, that song. And so the Lady in Red, yeah, maybe Lady in Red. And so the four principles of nature of the work, extent to which it has been copied, does it eat into the sale of the original product, those kind of tests will apply, and you will determine is it fair use, is it not. Now that's as far as the first element is concerned. Now, second, very, very important, that in India, let's assume that both the inventor and the human, both the machine and the human are co-inventors. They could be co-inventors. It has never been the law that you have to ascertain what percentage has been contributed by whom. You just file A and B as co-inventors. You don't say 5% was done by a human, 95% was done by a machine. That's true for copyright, that's true for books written, that's true for articles. You just indicate the co-inventors. It does not affect the quality of the end result. So the end result will always be patentable depending on our classic concepts of novelty, utility, non-obviousness, insufficiency, and perhaps a section 3 kind of defense. In this case, probably 3K. Now, one thing which is different in India is that assuming that the machine is the sole inventor. Indian law, Article 397 of the Constitution, says that the General Clauses Act will apply in interpreting the Constitution and other statutes. Now, the General Clauses Act defines person as including a juridical person. That is the reason why in the Ram Janmabhoomi case and many other cases, idols in a temple, deities in temples, ships, forests, wildlife, animals, they've all been held to be a person, a juridical person, although not a natural person. Therefore, it may well be that in future, applying this kind of a broad interpretation, a court might hold that a machine can equally be an inventor, although at the instance of a human. So for example, under the Copyright Act, a computer-generated work is an definition of author is a person at whose instance, the language used is, who was responsible for causing or caused the work to be created. If it is computer generated, it is like an AI, a generative AI. So if by that analogy, the person who's responsible, who either owns the machine or if not owning the machine is the one who gave the correct prompts and therefore resulted in a particular, because there is lots of evidence that by changing the prompt even slightly, you can come closer and closer to a certain end result. You want a Picasso painting, change the prompt a little, you can change it. Another change, you can change it. So there's a lot of artistry involved, or talent involved, skill involved in coming out with the output. So I don't see, therefore, the question of inventorship as affecting the final product. And the inventor could be mostly a human under the present AI laws. In future, perhaps co-authors, human and machine, and worst situation, if it is only machine, our interpretation of the way the Indian Constitution and all that may treat the machine, a juridical person, as a person entitled to inventorship.
Cordial thanks. Before I come next, maybe to you, Badri, because you are a patent person, and ask you what you think about what should be the ordinary person skilled in the art who would have easily come to the invention or not if he only would have had such a machine available. So we may have to redefine what a patent examiner should do. We don't know this. But I have a remark before. We have a nightmare in Germany, at least, also in Austria, of course, because the law is very similar there, employees' inventions. We have an employee. There's this wonderful AI system owned by the employer. The employee is entitled to get a special remuneration. You cannot include this into an employment contract. You cannot say whatever he makes, he has to assign or something and does not get anything than a US dollar. Oh no, a special success depending part of the commercial value of the invention for the employer. So we can solve it probably via the so-called share factor. That means who contributed to what percentage to the end product. Is it, in this case, this person who had nothing than this intelligent idea, oh, should we take the AI system for making new turbine blades? Maybe it's useful for that. Normally it is for making bicycles. I don't know what. Or is it the system, because that is the essential work which is being done. So I like your approach a lot, Brevin, where you say there could be mutual, there could be several inventors, a system, a natural person, how much is the contribution of the employer, of the employee. It's a second nightmare problem we have with this 60,000 employee inventions per year in Germany, under German law, binding law, by the way. You cannot trade this off by any employment contract. It's a very big problem. What do you think about the question of novelty and inventiveness now?
No, I'm okay. Thank you, Praveen. Again, a warm welcome to everyone and a very good morning, and thank you for inviting me on this panel. It's always a pleasure to be part of this panel. Thank you so much for that. I think AI presents unique problems that we have never faced before. So when I try to describe AI to someone, I think today, for example, ChatGPT is in our fingertips, and I'm sure a lot of lawyers in our firms and outside are using ChatGPT very innovatively with a lot of prompts, I think. And maybe they can come up with some very interesting things. But I always feel that if you actually look at, if you have to really understand AI, it's like you've got kids who got F1 car to run, okay? It's a Formula 1 car. It's got a linear regression. They've got so many algorithms. The way you kind of turn it and use it, it can come up with various different results. That's one of the ways I see. Can I drive a car? Yes, of course I can drive a car. But can I drive an F1 car? Maybe not everyone can drive an F1 car. But at the same time, it's very powerful and very exciting, okay? And everyone wants to take it for a spin, okay? Why do I say that? Why I'm saying so is that AI is creating some paradigm shifts. Like what Praveen said, we are not in this period of general intelligence, okay? We're probably having a few companies like Tesla which are getting to that place. And AI is impacting a wide range of industries. It's not just any and every industry. So we have perception being changed, motion and movement impact is happening. Natural language processing that we all get impacted, generative AI is getting impacted. So what we are seeing with AI is that it's a completely different paradigm which is coming up with respect to how to generate it. So when you come up, so two aspects to it. First, I'll just talk about the ordinary person skilled in the art, what we should say. This is the first question that you posed to me. You know, as a patent attorney who practiced in the US before I made it back to India, I had the pleasure of looking through these areas very, very closely. And I always found this ordinary person skilled in the art very interesting because I don't think I've ever found anyone in any invention who's been an ordinary person skilled in the art. I always found myself as an ordinary lawyer trying to find this ordinary person skilled in the art. But I still feel that some of these tests which are time honored are to be applied and judges and lawyers will find good ways of being able to find a way of fixing these ordinary person skilled in the art tests for the purpose of being able to come up with an invention. So what is it we are seeing? So an ordinary person skilled in the art should be able to make a determination and see whether the invention in question is inventive enough, that is non-obvious and novel, correct? My worry with having a higher threshold of ordinary person skilled in the art, that is a team of specialists with an AI system, is actually going to have an impact on the state of the art itself, okay? On the state of the art itself. So as you know, AI is generative. So when you are going to compare the AI as an ordinary person skilled in the art with an AI system, you are probably coming up with newer and newer art as it is getting generated with respect to that. I also feel that there's a lot of hindsight bias when it comes to AI. So I feel that tinkering with a time-honored ordinary person skilled in the art test in the context of AI is something that we may not want to do. I'm not very, very keen. I don't even know. It's hard to conceptualize who's an ordinary person skilled in the art in computer-related inventions. It'll be harder to come up with a higher standard of a team of ordinary person skilled in the art with an AI system. I don't know what that means because most of us probably don't understand what that means, and I don't know what our AI system will generate. Depending on what, say, Praveen prompts, it gives another answer. Based on what I prompt, it gives a different answer. So I think that will create a lot of uncertainty in the test. And we want, in these contexts, certainty so that the courts can come up with an answer for the purpose of being able to do that. So that is my point with respect to ordinary person skilled in the art. I feel that we should continue to use the traditional time-honored this thing, and I think trust the lawyers and judges to come up with appropriate application of these tests for the purpose of being able to do so. And so that's what I feel should be something that we should work with and maybe give more guidance as to how to apply this ordinary person skilled in the art. I hope that answered some of the question at least.
First of all, I will briefly comment on this. In a moment, but I would just like to welcome now Mr. Mohan Yuan. He is online now. He is not in today's version of the program mentioned, but in all earlier versions you will find him. We pre-discussed with him some time ago, and my proposal would be that we do the following. Mohan, we will speak about subject matters here with the persons who are here in presence, and you have the privilege then, you can hear what we all say, sense or nonsense, and we'll have then kind of a final word after our session when we have to give up because time is out and we are a little bit behind schedule, as you know. So welcome that you also have joined. Now we have in the European Patent Office, I wanted, you know these things there. We have since a long time already this concept developed essentially by Professor Peter Meyer-Beck, the former presiding judge or chief judge of the Patent Senate of the German Supreme Court. We have since a long time, the European Office applies this also. This is the ordinary team skilled in the art you are talking about. And what they try when the question is raised, is there a problem which could easily be solved by certain adding features to something which you find in the closest prior art, you would say, what do they do in practice? So you would say, let's say you wish to make a new disc brake for a bicycle. Whom would one ask in industry? Because we have a cyclist specialist, I come to you later on, next to me. You would probably not let somebody who makes usually bicycles without brakes to do this alone, but you would put a material specialist knowing about properties of ceramic brakes. Maybe you would put somebody who knows about how the signals from this brake, maybe temperature or whatever, could be processed in order to make an even better brake or so, and you would put that team together. This material specialist, the bicyclist specialist, the software or electronic specialist, could they easily find the solution which consists of putting 2 or 3 pieces of prior art together? We have this already, and probably, and in DPO there are big discussions about this, don't we also have to say the following? We have to reconstrue, to recreate the situation in which this inventor, Predvin, has been sitting. Do we need to have now an examining division having the same AI system, and would they come to the same solution?
A person of ordinary skill in the art is a human, till now. That is a non-existing human, a fictional person. But he is human. He has human qualities and weaknesses. He is conventional. He is not an inventor, etc. Now compare that to the complex issues which machine learning does. Machine learning finds patterns which the human cannot see. And therefore, whenever you compare machine with human, the machine will win. And when machine will win, all your inventions will be non-obvious. And so the patents will get granted much more than they probably should. So now to get a balance in place, you need to have a machine of ordinary skill in the art. Either MOSA, either you have that, or a human who is assisted by a normal human, average human, assisted by an average AI. The kind of AI used in that particular industry. And then you have to see whether fed the same queries, whether there was a possibility of that average human empowered with average algorithm and average data set, we would be able to come up with a solution. Then it is a proper comparison. Otherwise, there is no comparison, and the standard of AI, of inventiveness will change. This is what I feel. Now the question is, too much of importance is given to the algorithm, with very little importance given to data sets. And how do you select the right data set to bring about a reference? The correct data sets will ideally be those which are used to create the model. But then the question will arise, how do you get those? Will the court enforce an inspection? Will the person defying confidentiality concerns part with that data? So all these questions will arise in future. At the present moment, we are, like you rightly said, Badri, we are at a state when these issues are still in the hodgepodge.
I can only say, I mean, there's not a sheet of paper which could be put between you and my position here so far. And I'm sorry a little bit for the audience. We are giving you stones instead of bread, what we say in German. These problems we can show you, but all these problems need to be solved, and they need to be solved very quickly, because AI is progressing with exponential form into all areas of life. Now it would be interesting to see what does the Supreme Court in India, what do the advocates working there and at the court, what is a present status of decision? Totally undecided? Is this fluctuating? Is there a certain line one can already see? I would be very grateful if you would comment on that. Yeah?
Thank you so much. It's really interesting to be part of this panel, as Badri mentioned, and look forward to contributing on this. There are 4 primary issues that I wanted to pose as a thought experiment, I would put it this way. The first and foremost is, we are talking about machines as inventor, right? Is that just rhetoric? Is it a Pyrrhic conversation, or is there a rationality to it? The reason I'm posing this first proposition is, ultimately, the patentee remains a person, an individual or a corporate entity or even a government. So when you're talking about the difference between inventor and patentee, and where the patentee remains a person, then what really turns in terms of listing a machine as an inventor as opposed to a person? Nothing turns, right? So that's the first proposition I wanted to put forth. The second, you have three litigators on the panel, so it's no surprise that Mr. Anand already covered a lot of what I
Come
want
to
to
the
say.
practice later on. Yeah?
He's the odd one out here. Nirupam is an old friend who has been part of law publishing, so he's very thorough on all this. But yes, so when you have litigators on a panel, we always go into these nitty-gritties. So I'm not surprised Mr. Anand touched upon the second proposition, which is about who is a person. I only digress a little bit from what he said on the ground that if you look at the Patents Act also, there is an inclusive it's an inclusive definition in the Patents Act, which says a person includes government. So you already have a pointer both from the General Clauses Act as well as the Patent Act that not just a natural person, which is the trend you see internationally, but also a juridical person can be an inventor, as far as India is concerned. So when I look at this proposition of a juridical person being an inventor, my take therefore is that it cannot be a machine, because a machine cannot be even a legal entity, right? And therefore my variation from what Mr. Anand said in saying that a natural or a juridical person can be an inventor, but it cannot be a machine. The third proposition I put forth is an interesting one, a little digression on the thought experiment. You own a piece of land. You have a tree growing on it. So the construct that is already evolved in terms of law is that you will benefit from the tangible developments or derivative products which come from the tangible property that you own. Now we are talking about the proposition of intangible property coming out of tangible property. And would you still own the intangible property therefore? And if you do, then is it not the person behind the wheel who is the owner then? And not the wheel itself or not the machine itself, right? So this is the next proposition therefore I'm putting forth, and I'm saying that as the person who owns the machine, who is feeding the machine, who is giving it the path to take, who is contouring the conversation, so to say, would that person not be the owner? Would it make the machine itself the owner, therefore? And moving forward on that, necessity. One of the other arguments I keep hearing constantly is, we need more inventions. If machines can do these inventions faster, then why are we hesitating to acknowledge that aspect? So again, I draw this distinction of inventor versus patentee to say, machines will continue to invent as long as you keep feeding it data. It's not going to stop inventing because you didn't list it as an inventor. It doesn't, sentience is important, but sentience hopefully is not going to give it an ego which is going to say, oh, you didn't list me there, therefore I'm going to stop inventing from tomorrow, right? It will continue to invent. So this concept of listing it as an inventor is merely creating a fiction which has no real gain out of it. That's just the third proposition I was putting forth. And finally, you need to have a person who will be able to assign rights. And again, for that, you need the natural or juridical person to be able to assign the rights. And therefore, given this limitation that would then come forward, if machine is listed as an inventor, I personally feel that India is likely to go the same way as most of the courts have across the world, to say that it would have to be a person. The variation I see happening in India is, it is likely to be both a natural and a juridical person, and I don't see it being restricted only to a natural person the way it has happened, for instance, in UK or in Europe, etc. with this and what you mentioned about Supreme Court itself adapting AI, again, I personally feel that evolutions in AI, use cases in AI, the relevance of it and the importance of bringing out innovation in a speedier fashion is critical. But that would happen irrespective, as I already pointed out, of whether AI is, the inventor is listed as the machine or the person. And the final word on it is in terms of, some of the copyright instances that Mr. Anand pointed out also. You had the monkey selfie case, which already, and also the autonomous vehicle cases from across the world, particularly from the US, which made the person behind the wheel liable. You have a requirement under Patent Act for an invention to be for a legal and appropriate purpose. So you need sentience to work not only in generating relevant or useful innovation, it has to be appropriate. And it has to be for a legal purpose, etc. And there is a liability that would go with that kind of an innovation. Who is going to bear that liability? When you look at copyright laws, invariably liability has been vested with the person behind the wheel, not with the autonomous vehicle, not with even the manufacturer, etc. So the ultimate user has been put the onus on. Right? So when you're talking about AI and machines also, therefore, I would say the criticality in terms of holding the person behind the wheel liable, the person who fed the data, garbage in, garbage out. How many times have we heard that in terms of AI, right? So if you're going to put the person behind the wheel responsible, giving them the patent is, according to me, not a big issue. So that's just some of the thoughts I thought I'll start.
I like this last example particularly. The person behind the wheel, and there's this wonderful autonomous driving car with sensors, and nearly everything he can do or she can do not drive because the person behind the wheel. Now comes the question, is the person behind the wheel entitled to drive such a car? Because it drives still a car which is owned by a patent by somebody else. It is covered by this. So don't we need an opening clause? Don't we need possibly a clause which says, we have it in Article 24.2 of German Patent Act, India has something similar. I don't know which paragraph it is in your patent law. It is at least in TRIPS. If you make an important improvement of an already patented thing, it doesn't matter what it is, you are entitled to use it under a special kind in our law of a compulsory license, namely a cross license. That compulsory license comes at a price. Only if you allow also the owner of the, I would say, primary patent, who has the car patented, the AI system patented, whatever, he has to give a license to you as the driver now, but you must at the same time give a license also to this person who has patented the system, which does, according to German law at least, it does not need checking of any public interest. Public interest is always assumed because it means a procedure by which the new and improved invention, the total invention now, driver plus the car, etc., the whole system can be brought to mankind. This is public interest always. It is never ever checked by law. But also, German law at least does not prohibit balancing cash payments on top of that. It does not say cost-free. There must be a reasonable, now we all know, we speak about this later today, SEP, friend conditions, and whatever I would say it has to be a fair, reasonable and non-discriminatory mutual compulsory license, and then with necessary appropriate prioritizing, maybe valuating, somehow determining the value of the inventions. That might be a solution. That is something interesting, but now we must go back to earth, because here are practitioners, here are not only lawyers, here are not only legal scholars, I would say, for intellectual property law. We have some people here who need to run a company making bicycles, making motorcycles. Do you in your company, that would be a first question, use any kind of artificial intelligence already, and for what? It would be very interesting to hear about that.
Absolutely, and in fact, AI, we not only use it, we build it also, because it's a relatively new technology. And we use again for customer experience improvement, because the technology can use data and give outcomes which enable us to identify, for example, which customers we will be retaining, which customers will churn out. So these kind of tools and methods are available with artificial intelligence today. And not only this, these are continuously being improved. For example, we have generative AI applications. We are building them which make customer experience, for example, for customer support. So people call us and they have questions around our products, our services. So are much more natural language oriented, like we have the ChatGPT now based solutions, and also open source solutions. So it's not just a closed solution. So we have different solutions that we have built and again are available internally. We have not really launched outside, but yes, they are available. And the whole discussion, again, the good part of being in this panel is like you have given so much of inputs in different and so much of thought experiments to come to this, So I can, just making quick comments on what I have heard from all the players. So the first part is, the first question is, when can AI systems be creative? And I think the last year, 2023, was the phenomenal year where it became mass adoption, where ChatGPT kind of systems came in. And we call it generative, some people call it creative, but that is now available, and these systems are creating content. These systems are creating pictures, these systems are creating voice, these systems are creating videos, and also analyzing a lot of data and creating new content. So which may, clear out non-plagiarization of the stuff. So you can't say this is copied, this is absolutely new content. So that is available. Earlier, like in 2016, we had this game of Go, AlphaGo versus Lee Sedol. And there was, in one of the games, fourth game, I believe, where the computer created a move which was not even fed into that system. So that move was not in any database, and the computer generated that move, and that actually won the computer that game. So that was phenomenal. In another game, computer made a wrong move also, which was again creative, and lost the game. But so the creativity is there in AI systems. So we cannot say it's only data in, data out, because systems are actually creating stuff. But of course, not to discount the quality of data that is being put in. Second question is, like, can invention created by system be patentable? And I think that's where the biggest question lies. And I think I really like that thought. I had not even thought about what Mr. Anand talked about, whether creating an artificial jurisdical person of machine, so let's, like some countries have done, UAE, Saudi, they have given citizenship to an AI robot and doing a lot of stuff like that. I mean, the challenge lies is, like in a company, we have directors, like in an HUF, we have Karta in India, it's an Indian construct. Who would be that person for a machine? That would be the question, So who do we actually go back to that in case, who's the owner? Because if I'm using the same machine and he's using the same machine, so how does the machine owns the intellectual property, and who actually owns that? So that another question will come into this place. The bigger question is, do we need protection for the machine-created content? And I think Mr. Napani said, just because we do not give protection, it's not that machine is going to stop creating innovation, it will create. The only question is, do we need to create? And the bigger question is, like in earlier age, for example, photography, I took this example, taking a photograph was a real endeavor. The technology was not very available. I'm talking of 30s and 40s. You need a lot of preparation, you need a lot of expenses, and my father was a very good photographer, so, it used to be a really expensive game, and, you don't want to protect that. Today, taking a photograph is like a child's play, you take out a phone, you click hundreds of photographs, you don't even bother, where they are. Do you really need that kind of protection, unless it's this modicum of creativity, and, the sweat of the brow is now really gone out of it, so what kind of protection you want to give is a question from when the technology becomes mass available. Because the understanding is, with time, the cost of technology will go down. So if everybody has ChatGPT here, do you really want to say if ChatGPT creates some image, you want to protect that? Or Stable Diffusion or DALI or any other software, similar software does that. So that's interesting. So the question again I have, and here I kind of disagree with Badri, is I think the ordinary person's skill in the art, I think that needs to incorporate AI tool into it, because otherwise there will be hundreds and thousands of inventions and people will start filing it, So I mean, because the tool is available and all of them are inventive, the stuff would be inventive to ordinary person, but not to a person with AI. So that, I think, that needs to go up the bar, and that's my viewpoint. Again, you are ready to...
No, I think I'm very happy for people to agree and disagree. That's what this panel is supposed to be. I just wanted to come back to Napin. So just a couple of points, and I wanted to kind of just because I see where you're coming from, and as litigators, our main thought process is that there's a person, he's got ownership, there's an inventor who creates. So generally, I think we need to kind of dissociate these two things. Why Praveen was saying that there is a possibility of a AI system being a co-inventor is because we are going to see innovations which will not be humanly possible going forward. So the first question is going to be, you're going to start seeing patent applications of things and inventions which we know by looking at it is not being done by a person, because that's the kind of technology which is coming up. So that begs the problem that if, for example, the person who is put as an inventor is not the person who's capable of generating it, did he use a tool? And the problem that comes after that is that, let's say, Nirupam is the person who actually is the inventor of the tool. Should he become an co-inventor in this application? And that's the reason why trying to go down the path of whether an AI is a co-inventor and then to figure out who's the real inventor behind that co-inventor is probably going to be a case where a lot of litigation is probably going to come.
Yeah.
And just being able to identify who the inventor is probably going to be where we are really going to have. Now we have a debate.
Yeah.
In India, we love the debates. Huh?
No. So, it's a very short, yes.
Just to add, so again, just... again, when you talk of AI, again, there are three phases: artificial narrow intelligence, ANI, artificial general intelligence, which we are thinking, OpenAI saga was there, we are very close to, and the artificial super intelligence. So the point I'm making is with artificial super intelligence, and again, whenever we reach that 5 years, 10 years, 30 years, I don't know, maybe 2 years, that thing will start creating intelligence on its own, so inventions will happen like crazy. I mean, and we again have to be thinking through, how do we want to handle that situation? So I'm just leaving that open here.
Yeah. So I just wanted to make a very quick point to distinguish attribution from invention. So effectively, what your point in terms of, Badri, what your point in terms of co-inventor was, is about attributing the process, not about the person who is behind an invention. And therefore, I would still say that the case I put forth in terms of saying that it would still have to be a person, legal or juridical, holds good, because ultimately, even though it may be an invention which is done using AI, which could not be done by a human otherwise, it would still amount to only the process of attributing the machine with having been part of the process and not by giving it a tagline of inventor.
We have this problem of who is a co-inventor and only a contributor of a non-inventive nature. Of course, since, in Germany at least, since the times of the German Empire, this was 1930-something or so, and they have said there's a solid case law, otherwise you would have to turn it upside down. It says, whatever feature is in a claim, and there is general case law, you have not to put into the claim something which is a matter of course. This is not an inventive contribution. Whether it is a main claim, a sub-claim, whatsoever, whoever is with a feature there, that person is, including, of course, Mr. Boan, also, you write it to the organizers, email, and they will send it to the discussions here. I always like out of these meetings like here's today that we get into a kind of a continuous discussion process afterwards. And I promise, for my person at least, and I think I can say this for the other speakers here and panelists also, we do this then cost-free to answer these questions. Not in the form that somebody sends us an invention specification and we have to make cost-free of it a patent application and a granted patent later on, but general questions in relation to what we have discussed, do it in writing, including, of course, the unfortunate speaker who, as Mr. Dorn, who could not be here today, send it in, and I would like to ask the organizers to send it, and please, if somebody has asked questions from the audience, address also a specific of the panelists, or some of them, that we know where the question should go and who would have the moral duty at least to answer that question. Maybe all of us. Now I would like to use the very last 1 minute out of the 5 minutes, which I have long time over done already. I start from the left, a final comment, what we have discussed, what would be most urgent to do. Starting with you. Yeah.
I did not expect to get the 1 second here. So I would just close out by saying that these are all fascinating questions, and I would really look forward for jurisprudence in terms of technology itself and AI in particular to evolve in India, and very precisely what we have already discussed and the point that I've already made, which is that I personally feel that when we are talking about patents, it's about the focus is more on the patentee rather than merely on the inventor, and with that, when you read both together, the person behind the wheel would be the inventor invariably.
The one point which is a very important point in the Indian context is patentability of an AI program, bringing in section 3K of the Patents Act. And for that, I think we've already got our technical effect and technical problem, technical solution, technical consideration kind of case law with Ferrari and Microsoft and all. I'm not touching. What is important is that emotional perception AI. 2 minutes. Emotional perception AI is a recent case decided in England, and I think very important principle came out of that. Namely, that if, for example, AI is purely a mathematical concept or heavily mathematical, our law uses per se only in relation to computer software. It does not use per se for mathematical concept or business method. The result is that you will have to draft your AI program to work on a computer which then produces a technical effect. Unless you do that, if it's just purely AI without the involvement of a computer program or a machine, you will have a problem because of that per se not being applicable for purely mathematical concepts. That's an important thing. And I think that came out of emotional perception, which is a must read for everybody.
So, last word, Barry.
Always like to take the mic from you. I think last word I want to say is that a couple of things. One is we are looking at it from an IP perspective, but I expect in the next couple of years, regulations and law relating to AI itself. So that's going to have an impact on all regulations relating to IP. My last comment, of course, along with that is that as most people who are in the room who are prosecutors, I feel that, when we looked at software, there was a large divergence between the practices that different patent offices were going about. And I feel in AI, that divergence of prosecution of these applications is going to further diverge. And I think there will be a lot more differences between the different patent offices, and therefore, the skill in drafting the patent application is probably going to be the highest level when it comes to AI application. That's what I thought I will leave that to you.
So I would like to add is that what we need is again not just again patenting or copywriting for sake of it, but whether it's really create value for the consumer and the companies that are creating this stuff. So what I see is again a huge explosion of AI tools that we all will be using, whether knowingly or not knowingly. And again, the technology and innovation speed will go up, and we will have a lot more innovation. So we need to again rethink the benchmarks for innovation and patentability. Thank you.
Maybe a final word by Mr. Leonore. What would be the most urgent problem we should solve with regard to answering questions how AI created or contributed inventions should be handled in future? What would be your recommendation?
So my recommendation is that things will evolve with time. At the moment, let us not look at the machine as a significant. Let us treat the machine, which is really a mathematical calculator, an advanced mathematical calculator that speaks in binary language. Let us leave that alone. It is always and only the brain of the human mind that is going to be primarily the concern, and having invention skills, because the ideas will be generated only from the human mind and not from the machine as such. That is my last feeling as of now. That's how it is going to work. That is how we should look at it and give all importance to the human behind that machine that is operating, that has the ability and the skill to operate the machine, which has incidentally has a large language model and a couple of large language models fed into them.
Yes, thank you so much. I mean, from my side, the very final word. Originally, I am still a German attorney, and our case law, developed by the Supreme Court of the Reich of the German Empire since the 30s, always said an invention has practically two inventors, or partial inventors. The one is to put the problem forward, the other one, the solution of the problem. The invention consists of a problem and a solution. And I think we have to go back to this wisdom because it will answer many of these questions we have here already today. Your wheel driver would be obviously the solution, the problem putter, and the car does the task. He drives at the end of the day, but other direction. Thank you very much, both our foreign participants and also the audience, to have been so patient. You must be hungry, thirsty, impatient, whatsoever, and particularly my co-panelists here. Thank you. I have enjoyed it at least. Thank you so much.
Thank you. Thank you.
Thank you, moderators and all the speakers. I request Dr. Dampatram Agarwal to please give a memento for the plenary 2 session. Thank you, Dr. Agarwal. Now, before we move for the lunch, let us have one group photograph in this hall itself. So, I request all of you to please join us for the group photograph. Then we will proceed for the lunch. Thank you.